Good afternoon, Merit Center and Board of Public Works and Safety. Hope you all had a nice Easter. I am not able to attend the meeting in person, but have now learned the hard way that any presentation needs to be provided in a link prior to a meeting so that it can be viewed. Phil Blessman and I, Audrey Blessman, are requesting reinstatement of our fence permit pertaining to the segment of our north property line so that we can maintain what is installed and complete and assemble the unfinished portion. This segment area corresponds roughly with the first 110 feet of property boundary, so essentially where the 110 property has yard and grass abutting the alley. So according to the City of Plymouth zoning ordinance, it seems this is a permissible fence. Fences are permitted up to the property line, and fences shall be permitted within easements, but we need the approval of the Board of Public Works and Safety. Now, the Board of Public Works and Safety did already approve this. I know it was a different circumstance, but I just think I want to just remind everybody that all the department chairs already have weighed in and said that there wasn't a problem with it. Of course, I know it's a different situation, but the installation preparation for the fence is essentially completed. So there's no risk of damage to any pipes, as we took very good care to dig carefully. The fence does not pose any danger, nor would it materially hinder traffic on the pavement. That being said, we will expand the passageway southward to make up for the width of the fence and any pavement which may have been north of our property line. So over the years, some of the pavement encroached into the north neighbor's property by about 6 inches, and that happens mostly towards the back of the easement. We will most likely remove the large evergreen trees on our north side yard entirely. When we planted them, we thought they were arborvitae, but I think they're a different variety because they're just a lot wider than the ones we have on the other side of the house. If it's feasible to trim them, we'll try that first. We also plan to replace the wood panel fencing on the north side of the house, which is only temporarily installed, with a white fence panel so that both sides of the house have matching fencing, and it will also promote aesthetic continuity with the fence, which is on the north property line, if it's permitted to remain. We wish to maintain the fence as it provides privacy for our property and alleviates some of the aesthetic issues, in particular blocks view of a chain link fence, a plywood patch deck, dilapidated shed, and swing set with a ripped, rooftop, and all the while allowing us to maintain the enjoyment of the overhead and above ground openness of our own property. I also work on lots of projects and have things in my yard, and I don't want other people to see that either. And so it also makes me feel better about not having my neighbors see, like I'm replacing these, beams in the back porch, and it's just a lot of mess. So, the privacy benefit that goes both ways. We did enhance the fence after the city revoked our permit, but we did so because we were given the opportunity to present our request to the city council, and it made sense to make it look nice for you and just for everyone's benefit in general. It's fair for you to know a fence panel very similar to this one was installed over the alley before our fence permit was revoked by the city. It lasted for less than 1 day. A large gray pickup truck plowed into the original panel and shattered it to bits. I was in the side yard when it happened. And of course, I turned when I heard the noise and watched as a big sort of silver grayish truck finished backing out of the driveway and sped away. I didn't even tell Phil about this, as I was pretty traumatized by it, as he sadly warned me that something like this might happen. There was a chance, though, that it was an accident. By this time I had removed the orange construction cones, so a vehicle that was used to maybe quickly turning the corner and speeding up the alley, as happened frequently, may not have seen the fence in time. Though I think if it were an accident, the driver would have stopped to talk with me. After this, I created a barrier with boulders. In any case, I'm fairly certain that things would have gone a lot differently had the whole process started with a public hearing. That process allows for the public to be informed through the city, not by their neighbor, and also to be able to give information to others. In essence, to be heard, and that's really important, that people feel their voice matters. Sean Cerisi has apologized for leading us down the wrong path, but I don't think he knows or the city understands just how much damage this particular error caused us, whether or not we would have taken the fence down after it was revoked. just putting up the fence without the city communicating to our neighbors and to the community is the main grievance that a lot of people have. And even though the city revoked our fence, I don't think a lot of citizens and residents understand that the city actually permitted the fence in the first place. There's been so many errors, and without the city taking an active role in communicating to our neighborhood, and now without the city allowing our presentation to be viewed for the public at the public hearing, they will most likely never know the truly unusual, complex, and amazing, fascinating circumstances which are connected to our property and to the 1892 easement. And that's a loss for everyone, especially for us. During the council meeting, on the 11th, Mark Honer, the neighbor directly to the north, claimed that he found out that the fence that we had put up was sitting on a portion of his property after having it surveyed. He provided no evidence, no photos, no reference to any particular part of the fence, but just made that statement, which was printed in the paper. Had our presentation been displayed for the public and the city council members as requested, everyone would have heard and seen a segment addressing this specific claim, this misconception regarding the fence on our shared property line, as well as a few other relevant facts pertaining to the Honer property, several of which we had discussed with them already in 2021, so we knew it was going to come up. But relevant to today's request is that the Honers, contended that the fence was on their property after their survey was done. First of all, we installed our fence after the Honers had their survey. Their survey was conducted by Bernard Feeney on January 26, 2021, and the portion of our fence on the north property line and over the alley was installed after September 15th. So we had a heads-up email that went to Sean Cerisi, which establishes the date for this portion of the fence installation. We feel confident that no portion of the fence is on any portion of the 110 South Liberty property. Of course, if we made a mistake or an error, we would certainly correct this, but we are very careful to use 4 survey markers to establish our shared property line as follows. It became evident to us that the former clerk treasurer, Tony Hutchings, had a property that had basically just ballooned. So not her property line shifting in one direction, but every single property line was opened up, just spread out up to 6 feet in one area. And so Steve Schoberg had a survey done, and we chipped in for that. And from that, we were able to get the fence line for our back fence, and also the line marker for the south property line. So we had the west property line and the south property line with stakes, and also the actual official, metal monuments that were installed by Mr. Feeney. So the conglomeration of parcels is pretty weird here with those staggered parcels. But, we had the 2 markers that were on the asphalt that Mr. Feeney put down for the north neighbors, and then also the marker from our corner with Steve Schoberg that we pitched in for, and that one we had an actual stake for it plus the metal marker. And so with that one, we were able to measure the 12 feet just to verify, double check to make sure that the scratch marks that Mr. Feeney put on the asphalt was accurate, and it was. So from the front property, there's a scratch mark in the sidewalk that is basically at the end of this arrow here. You can see it very barely there. The mark in the back is a lot more difficult to see, but it was very nice that we had the stake and the monument from our corner with Steve's property to verify that it was, in the right spot. So I feel pretty confident that we were able to put the fence in properly. Now, there is an odd thing about the scratch mark on the front concrete. It's at an odd angle, and maybe the north neighbors think that angle means that that's the angle of the fence, but it's not about the angle. It's not like an XY axis that's supposed to be directional. It's just the very center of that plus mark marks the corner of the property. So I just think that perhaps maybe that might be contributing to them thinking that the fence is on their property. The front scratch mark is quite easy to see, and it's located approximately where the foot of this worker is, right there by that arrow. It's important to consider that fences are a form of obstacle, a legal obstacle which divides 2 properties. Given that the space that's between the fence and the yard is pretty much what's always been there, it's enough room for a lawnmower, I don't understand how this is a complication of any significance. And even if there were complications because of a fence, it's not a reason to not approve a fence. And
The homeowners navigate all sorts of barriers around their property where they have various objects in their yard. And the lawn still gets mowed in those areas.
So we've explained why the fence should be permitted and why we'd like to have the fence and how it's not a problem for our neighbors of any significance. The standard for ingress and egress can still be maintained with the solution that we offer. And it's just important to think about this easement. As owners of the property, we have the right to the easement area just like any other part of our property, as long as we don't materially interfere with the intended use of the easement. And I think we can get that done. Additionally, an easement holder cannot increase the burden or increase or expand the use of the easement on the servient estate beyond what is contemplated at the time the easement was created. We feel quite strongly that the city has already increased burden on our property beyond what was contemplated at the time the easement was created in terms of use. There were no cars in Indiana until 1910, so 1892, this easement was set up for the special needs and limitations of horse and cart travel, and it was meant as a secondary access to a property. An alley is specifically a secondary access to a property. And it's no longer used this way. It's used as a street, as this is the primary access for garden court residents, their family members, their friends, their CNA health caretakers, their pizza and other deliveries. It serves as a street, even though it's only 12 feet wide. And before we planted all these bushes, trees, and shrubs that were to the south of the easement, residents just simply drove up onto our grass and yard. So we had to plant all those bushes, and so we lose even more of our property as a result. So, including the utilities underneath the pavement and also utilities in the middle of the north yard, just some telephone lines that are under our grass. All this without a utility easement. So there's no question our land is being overburdened, and on top of it, we even have above ground unsightly telephone wires, all that stuff done without a utility easement. And I know everyone thinks it's okay because eminent domain, but there's a process for that. And our land has been abused, and the city just doesn't seem to care. It's especially shocking given that there are some very clear ways that the city can make amends and make things right. And when there's a way to make amends, or even statutory ways that the city is supposed to supply us with an alley, which I clearly believe is something the city's going out of their way to avoid, there's something really wrong. The discrimination against me as a woman, or the people here that are in the area that are with disabilities or low income, why it is that the city will give an alley to everyone else but not 150 feet of an alley to these 22 properties is unconscionable, especially given that the city knows that they have overburdened our property and they can easily make amends. Easily. Though we feel we have the right to the fence based on just the ordinances we've already outlined, I think there's an interesting couple areas in the ordinance that talks about modifications and waivers. And it talks about under conditions where a strict interpretation of requirements may either be physically impossible or create practical difficulties, an alternate compliance procedure may be used to maintain the spirit rather than the letter of the law. The proposed solution must be equal or exceed standard requirements. Well, anyway, I just think it's interesting, this idea that for unique situations, there's always a solution, and our property and this easement is certainly unique. Our requests are reasonable, and we appreciate your consideration. Thank you for your consideration. Keep in mind that if we install a fence, we would be the ones that maintain the fence. There'd be no burden for the city to maintain a fence. We will move forward with our request whatever way we need to. And it just seems it's time for the city to start being more compassionate towards property owners that have been overburdened by many errors that the city has made. And, I know it's hard to admit you have made errors, but if there's a chance to remedy it, the city should do that. And we hope that you consider our request to honor our petition for a fence on the north portion of our property as previously requested and as is currently installed. Thank you.